Good evening, everyone. Today we will be starting a very important chapter of your course. Okay. Uh, the topic that we are starting today is Companies Act 2013. Okay. Companies Act 2013. We have completed Contract Act. We have completed Sale of Goods Act. We have completed Ethics, and also we have completed partnership and limited liability partnership. So as I already we have discussed in the first class that your course is divided into two sections, section A and section B. Section A covers 70% of your course and section B is 30% only. Okay. Among this 70%, we have completed more than 50%. Okay, because we have completed there are four chapters in 70% wala part. Okay, among those four chapters, we have already completed three chapters. Okay, so only one major chapter from that portion is left, that is banking and insurance laws. Okay, that I'm thinking that I we shall do it at the last, because this is also a big act. So I want that you before exams it will be helpful to remember. Okay, so I am uh, putting this act on the last list. Okay, at the last we'll do this banking and insurance act. Okay, now from the 30% portion, that is section B, we have completed ethics. And today the major portion of this 30%, the most important act of this 30% is Companies Act. Okay, so we'll be starting this act. This is also a very lengthy act, very big act. I don't know why they have kept into the 30% portion, because people doing CS, people doing CA, executive, etc., a whole book is there for company law. A whole subject is regarding company law only. Okay, so this is a very vast art, so a vast act. Okay, so we'll be doing it in brief, because in deep it is not in your course. Okay, so we'll start from Companies Act today, and then these all there are many small acts also. They are of one or two lectures each. Okay, so don't worry that our course will be completed or not today. If we complete this Companies Act in 3 to 4 lectures, then it will be a great achievement for us. Maximum it will take 5 to 6 lectures. Okay, because this is also a very lengthy act. So let's get started without wasting any time. Companies Act 2013. Okay, Companies Act 2013, page number 265 of your module. I repeat, page number 265 of your module. Okay, this Companies Act, right now the name of this Company Act is Companies Act 2013. But earlier this act was called as Companies Act 1956, because this act initially came into existence in 1987 only. Okay, sorry, 1887 only. But due to certain complications, etc., everything, because foreigners, Britishers who used to rule India were also following this act. Okay, so initially in India, this act came into force in 1956. Okay, act was made in 1956, and that act was known as Companies Act 1956, because there were change in the economic environment. Due to the change in economic environment, like at the time, if we talk about the time at 1956, foreigners were not allowed, foreign companies were not allowed, India was not globalized at that level, Britishers were also there. So there were many consequences. Why? Because there were many problems facing on in the country. So this act needed a very uh, drastic change. Okay, why? Because every scenario from 1956 to 2013 have been changed. Liberalization, privatization, globalization came into existence. Then many economic policies were changed. In short, if I say, the economic environment of the country fully changed. So that is why this act was amended in 2013. This act was amended in 2013. So this act is made to consolidate and amend the laws related to the company. Why this act, Companies Act 1913 made, 2013 made? This act was made for consolidation and amendments. Amendment means changes, okay, and consolidation means putting together. So this act was made so that many earlier laws which are not so relevant in today's world could be avoided. Many new policies could also be added. Many lengthy processes could be, because there was introduction of liberalization. That means what? Licensing. There were very leniency in licensing. Earlier, if you want to take any kind of license, there was a lengthy process for every license. But due to liberalization, this licensing policy, whether it being export policy, whether it being companies, etc., everything was liberalized. Everything was cut short. So that is known as consolidation. Okay, so this Companies Act was made, is made to consolidate and amend the laws related to the companies. Now, for every act we have studied that when did this act came into force, but we will not study the enforcement date in this chapter. Why? Because Company Act is amended every other day. Okay, every other year Companies Act is amended. So it is very difficult to remember each and every day. We are studying Companies Act 2013, and it is on page number 265. Companies Act 2013, page number 60, page number 265. So this is the basic scenario. If I talk about enforcement date, this act, Companies Act 2013, the date on which it was registered in the official gazette is 30th August 2013. 30th August 2013. But there were some special provisions, some other provisions were also amended and added, and that date is 12th September 2013. On 12th day of September 2013, some other amendments were also made, some new provisions were also added. So if you talk about enforcement date, there are two dates. One is initially when it was recorded in the official gazette. So on 30th day of August, this act was recorded in the official gazette. And on 12th day of September 2013, many new provisions were added to this act. So if we talk about the legislation of this act contains 470 sections. So just imagine, this act is twice the Contract Act. Okay, so this act is very lengthy. Combinedly, this entire act has 470 sections. Don't worry, all the sections are not the part of your course, but eventually when you'll move ahead, when you'll move forward for higher studies, then you'll have to read this entire act. Okay, so initially there are 470 sections, 7 schedules and 20 chapters in this act. There are 470 sections, 7 schedules and 20 chapters in this act. So you'll have to remember each and everything, because straight away in examination this MCQ question can come, that how many sections are there in Companies Act 2013. So you will have to keep this thing in your mind, that this act has 470 sections. Okay, so this is the basic introduction of the act, that how the earlier act was there, then how it got amended, what is the enforcement date, and why this act is made. Okay, So now let us discuss the meaning of company. We are doing Companies Act. So before uh, moving to any further point, we have to understand what a company is. If we move to the definition part, then the definition of company is defined in section 2 subsection 20. Section 2 subsection 20. But definition is not self-explanatory. That is, if you read the definition, you'll not understand anything. Why? Because section 2 subsection 20 reads that a company is a company which is incorporated under Companies Act 2013 or any other previous act. So what does this definition means? That a company is a company, okay, which is incorporated under this act or any previous act. That is, if any company is incorporated under 2013 or 1956, that company is known as company. But actually, eventually, what a company is. So before understanding the concept of company, let us understand the word company. Okay, so this word company was derived from the Latin word. Was derived from the Latin word. This word is a combination of two Latin words. One is cum and next is panis. Cum and panis. Two words combinedly created this word companies. Now these two Latin words, cum means together. Cum means together. And panis means bread. So eventually in Latin, people coming together and eating their food, that is known as a company. But if we talk in layman language, what a company is. So a company is a corporate body. A company is a corporate body and a legal person having status and personality distinct and separate from the members constituting it. That means what? A company is a separate member. A company is a corporate body. That is, a company is incorporated, a company is given birth, a company goes on for infinite period. When we will read the salient features of company, then you'll understand what an actual company is. And after understanding what a company is, what are the features, we'll also discuss the difference between partnership and company that we have left in the last chapter. Okay, so in layman language, if somebody asks you that what is company, so a company is a separate legal entity. A company is a separate legal entity which is different from its members. That is, board of directors are different, shareholders are different, and company is different. Unlike partnership firm, in partnership firm, partners are responsible for everything, but in a company, members cannot be held responsible for everything, because company itself is an artificial person. Okay, we human beings, you, me, and everybody, our relatives, etc., are natural persons. Why? Because we can speak, we have feelings, we have everything. That is why we are natural person. But company is also considered as a person, but not a natural person. It is an artificial person. Just like me, I can do anything on my name. Just like me, company can also do anything on its own name. So if we talk about the meaning of company, the definition of company is given in section 2 subsection 20, which is not so clear, because it defines that a company is a company which is registered under this act or any other previous act. That is, if a company is registered under Companies Act 2013 or Companies Act 1956, that will be considered as a company. So I hope the meaning of the word company and a brief explanation of the word company is clear to all. Any doubt till here? Okay. So now we'll move to the salient features of company. What are the features that a company enjoys? What are the characteristics of a company? If you understand each and every feature of the company, then you'll be able to understand the meaning of company also. The first and most important feature of a company is it has a separate legal entity. That means what? A company is an artificial person, and it is difference from it is different from its shareholders, from owner. Even owner is not considered as company. Owner is different and company is different. Owner is a natural person and company is a artificial person. Okay, so a company has a separate legal entity. A company is an artificial person which who is different from its shareholders, who is different from everybody. Okay, excuse me. Give me a second, please. So a company has a separate legal entity. It is an artificial person and it is different from its shareholder. A very famous case was happening here. And that case, the name of case was Salmon versus Salmon Company Limited. Now, what this case clearly made everybody understand that what is the concept of separate legal entity, how a company is distinguished from its owners. So there was a person known as Aaron Salomon. There was a person known as Aaron Salomon. Now, what happened? This person, this Aaron Salomon, has a business undergoing. Okay, he did business of shoes. He was having shoe business. So what happened? The nature of the business was, it was a proprietary firm. That is, he used to look after everything. So later on, his sons also decided that we also want to be the part of your business. So what happened? This Aaron Salomon converted its business into a company. Okay, so Mr. Aaron Salomon opened a company and named it as Salomon and Company Limited. Salomon and Salomon Company Limited. The name of the company was this. So what did they did? They incorporated a company and named that company as Salomon and Salomon Company Limited. And they acquired this proprietary firm. They took the proprietary firm under their name, because company is a legal concept. Itself is an artificial person, so it can purchase anything at its own name. So this company, Salomon and Salomon Company Limited, what did they do? They acquired the business of Aaron Salomon and they purchased their business for 38,000 pounds. Okay, now what happened? Every company has members, shareholders, secured creditors, unsecured creditors, etc. So what happened? This company was created, Salomon and Salomon Company Limited. There were the members of the company. Initially, when the company started, there were 4 members. Actually, there were 8 members. The first member was Aaron Salomon. Okay, he was the incorporator also. He made the company. He was the owner of the company also, and he was the member of the company. Acquired. He had 20,000 shares of this company. 20,000 shares of this company. Second member was Aaron's wife, who had 1 share. Third member was this Aaron's daughter, who had 1 share. And 4 more members were there. These 4 were sons of Aaron. Okay, Aaron Salomon's son. Each had 1 share. Now what happened is, members were also from his family only. Okay, and everybody has one share except for Aaron Salomon. So he had the majority of the shares. So major decision making was in the hands of Aaron Salomon. The director of the company was Aaron Salomon only. There were two directors of this company. One was Aaron Salomon and another was Aaron Salomon's son. The creditor of the company was Aaron Salomon itself only. Okay. Now what did this Aaron Salomon did? He gave 10,000 rupees credit to the company and had a charge on the assets. Okay. So here this Aaron Salomon is the owner of the company, is the member of the company, is the director of the company, and even a secured creditor of the company. Okay, so this was the scenario of the company. What happened was, after 1 year, before 1 year, the company was running smoothly. Even when Aaron Salomon was a sole proprietor, that is when he was not a company. At that time also his business was running very smoothly. But after incorporation, after 1 year of incorporation, what happened? The company was facing financial problems. Okay, so they had to start the liquidation process. That is, they had to wind up the company. So before winding up, you have to undergo liquidation process. Now, what are all these terms? We'll be discussing in futures. Winding up means closing of the company. So because they were not solvent enough to clear everything, so they needed to wind up the company. That is, they needed to close the company. So they have to undergo liquidation process. Liquidation process is giving a proportionate amount to every creditor, selling every asset, all in all closing the company. Okay, so the total assets at the time of liquidation process, the total assets were of the company was 6,000 pounds, and the total liability of the company was 16,000 pounds. So now these assets were not enough to compensate the liabilities of the company. So what happened here was, whenever a company goes through liquidation process, the first priority is given to secured creditors. That is, firstly, whatever the assets you sold and the money that came from that assets will be first given to the secured creditors, then to the unsecured creditors, then to the venture holders, etc. This is a process of liquidation. Okay, so this is in this sequence only money is given. Now what happened was, the unsecured creditors came forward and told everyone that because the secured creditor is Aaron Salomon, the company was created by Aaron Salomon, the owner of the company is Aaron Salomon, the member of the company is Aaron Salomon, the creditor is Aaron Salomon, and even the director is also Aaron Salomon, so he should not get any money. Why? Because everything is done by him only. Because of him only this company is going into liquidation process. He is the sole owner here. He is doing everything on his own. So he should not be given anything. Okay. So this was the statement of unsecured creditors. So they went to the court. These unsecured creditors went to the court and filed a case against Aaron Salomon, this company, that the company should firstly give the clear the debts of unsecured creditors, and then nothing should be given to Aaron Salomon because he is the owner. So the court here gave the decision that company and members are completely different. Company has a feature of separate legal entity, that is, the company is different from its owner. Members may come, members may go, but company have its own identity. Okay, so here the name of the company is Aaron Salomon and Salomon Company Limited, and Aaron Salomon is just a member of a company, is just the director of the company, and is a secured creditor of the company. So firstly, the money will be given to Aaron Salomon only. So from this case, the concept of separate legal entity was very clear, that rather no, that there is no matter that who the owner of the company is, who has done anything in the company, etc. There is no such concept here. the company is based on the rule that company has a separate legal entity. That is, company is an artificial person. Company has its own name, and all the members are different from the companies. Members are not responsible for the name of the company. Okay, members can do whatever they want, and company can do whatever they want. Okay, so from this case, it was quite clear that despite Aaron Salomon was everything, was the whole and sole decision making of this company, but yet Aaron Salomon was considered different, and company, that is Salomon versus Salomon, and company was considered completely different. Both were different from each other. Okay, so is this case law clear to everybody, and is this the concept of separate legal entity clear to everyone? Answer yes or no, please, in the comment sections. Everything is clear till here? After a long time, you have replied, Mr. Kumar. Okay, let's move ahead. The next feature of a company is limited liability. Okay. Uh, each member of the company has a limited liability to the extent of share capital they have bought in the company. Okay, like for example, if I am a member of a company and I have 400 shares of that company. Okay, so in that case, if the company goes into liquidation process, if the company has become insolvent, then they can demand only 400 only rupees, which what is the value of 400 shares, they can demand that only from me. They cannot demand anything more than that. Why? Because every member of a company has a limited liability. That is, if case in case if the company becomes insolvent, then these members will be liable for the to the extent of their share capital only. Now this limited liability has different scenarios. In future we'll understand types of companies. There are different types of company. So one company is limited by shares company, and one company is limited by guarantee company, and one company is unlimited company. So in all these situations, the limited liability concept will be differing. Like if we talk about company limited by shares, what is this company, we'll discuss in future. Okay, so if the name of the company is company limited by share, the type of the company, then in that case, the share members of the company will be liable only to the extent of the share. And if a company is an unlimited company, then personal assets of the members can also be taken into charge. Okay, so this concept, this limited liability concept differs in different types of companies. So basically we can say that the liability of a member of a company is just limited to the extent of the share capital they have bought. Okay, the shares they are having at that time. Like if we talk about Salomon and company, Mr. Aaron Salomon was responsible for 20,000 shares. So in case of indebtedness, in case of liquidation, Aaron Salomon could be responsible only till the value of 20,000 only. That is, he cannot be demanded more. So similarly, in every company, every member has a limited liability, and that too to the extent of the share capital they have bought. Next is perpetual succession. Perpetual succession means the lifespan of a company. If we talk about a lifespan of a company starts with incorporation and dies with winding up. a company starts with incorporation and dies with winding up. In this complete span, members can come, members can go. Nothing is affected by change in number of members or change in any if there is any additional member or some existing member has left, there is no effect on the company. So perpetual succession means that company will go for a infinite, company will live for an infinite period. It doesn't matter that members are present or not, members are in the company or they left or they died or became insolvent or became insane, there is no impact on the existence of the company. A company will only die when it is winded up. A company will only die when it is winded up. Once the company is wound up, once the company is officially closed, winding up is also a chapter in future. We'll be studying that how a company is winded up. So when a company is wound up, when a company is closed, then only a company dies. Like in partnership, we have studied that if there is new admission of a partner or retirement of a partner or insanity of a partner or the partner becomes insolvent, the firm is also closed. Okay, but not in case of company. A company is never closed because of its members. It is clearly said that members can come, members can go, but company will stay for an infinite period of time. Company will stay for a longer period. Like Kingfisher, I was talking about in earlier classes. The owner of the Kingfisher company was the sole member of the Kingfisher company was Vijay Mallya. Okay, but what happened? Vijay Mallya became insolvent, then he left the country, then he ran away from this country. So what happened? The other people acquired this company. That is, they purchased this company. Still today, member have gone, members are changed completely, but Kingfisher company is still in existence. Okay, many products of Kingfisher are still in the market. Why? Because the company has been purchased by somebody else. Now members, everything has been changed, but company is still there. So this is the best example of perpetual succession, that whatever happens, whatever members are there or not, company will not close until it is winded up. So the lifespan of a company is from the date of incorporation to the date of winding up. This is the lifespan of company. Apart from winding up, nobody can close the company except for government in exceptional situations. Okay, that these exceptional situations are very different, but rather in ordinary sense, if I'm talking about, then nobody has a power to forcefully close the company. Next is separate property. Separate property means that a company can acquire or sell or transfer any property in its own name. Okay, the company has a power to purchase any property at its own name. Like for example, if we talk about CMA, CMA is also a company, is also a statutory corporation. Okay, it is created by a special statutory act. So if CMA is purchasing any building, so it will be purchased on the name of CMA chapter office. Not in, it will not be purchased on the name of chairperson or on the name of any other member. Okay, so a company has a power to purchase any assets on its own name. If Reliance Jio is purchasing any, if Reliance is purchasing any plant for example, for solar energy, then in that case, that name of the property will be on the name of Reliance, not on the name of Ambani's. Okay, so a company has a power to purchase or transfer any property in its own name. So if you are transferring any property or purchasing any property, then signature is required, right? So how a company will sign? Company does not have any hands. Company does not have any hands, but there is a common seal for the company. Common seal means what? Official signature, we can say. The digital signature is known as common seal. Before 2013, I can say, the common seal was compulsory for each and every company. Okay, every company needed to have a common seal, and on every document, whether it is purchasing, acquiring any other company, whether it is purchasing any asset, whether it is acquiring any property, whether it is transferring any property, whether any bill of exchange is made, etc., etc., in each and every document, the common seal was attached. That is, signature was, digital signature was attached. But after the amendment in this Act 2013, common seal is not compulsory. A company may have common seal and may not have common seal. But what happened if a company is not having a common seal? Then on such important documents, who will be signing? Who will be the signing authority? Then the answer here is, if there is no common seal, because now the amended rule says that company is not required to have common seal. It is completely optional for the company. So in that case, if your company is not having a common seal, then on all the important documents, the signature will be of either two directors or one director and one company secretary. Okay, so these people are also allowed to sign the important documents like bill of exchange, or if they are transferring any property, etc., etc. Okay, so common seal means the signature, the official signature, because company is an artificial person, because company cannot do everything on its own. So artificial signature is also created for the company. So that artificial signature is known as common seal. But in this act in 2013, the amendment came into force that now common seal is not required. Now common seal is not mandatory. So now it was also added that if there is no common seal of the company, then on the important documents, either two directors will give their signature, will give their initials, or one director and a company secretary, one company secretary will give their initials. So this is the concept of common seal. Another important feature of company is transferability of shares. Company the members of the company has a power to transfer their shares to anybody they want. Okay, there is no restriction on transferring the shares of the company except for private company. If it is a private company, then there are certain restrictions that we'll be studying in further when we'll discuss the concept of a private company. Except for a private company, if there is any other company, then members has a liberty to transfer their shares to anybody. Okay, they can transfer their part of shares to any other person. Like for example, if I am having 10,000 shares of Reliance Limited. Okay, so now I don't want to be the part of this company. Okay, so what can I do? I can transfer the shares. Share means what? I am also a owner of this company, right? I have also certain powers in this company. So if I'm having 20,000 shares, that does not mean that I cannot, if I'm not willing to be the part of this company, I cannot withdraw. No, I have a power to transfer my share capital to any other person. To any other person, I can transfer this very clearly. Okay, so there is no restrictions on transferability of shares. And last is capacity to sue and be sued. Because company is an artificial person in itself, and because of the separate legal entity concept, a company has a power to sue, and a company can be sued on its own name. Members cannot be involved. Okay, if company has created some fraudulent activity, then in that case a case valid case can be filed on the name of company. Like for example, if Reliance Jio has created some fraud with the customers or did something wrong, that in that case a valid case can be filed on Reliance, not on Ambani, because company is different and members is different. So these are certain features that are enjoyed by a company. So if we talk about difference between partnership and company, so there are many differences. Firstly, partnership firm is not a separate legal entity. Okay, partnership firm is run by partners. It does not have its own existence. Okay, So basic difference, first difference is company is a separate legal entity, whereas a partnership firm is not a separate legal entity. Second difference is in partnership, all the partners have unlimited liability. That is, in case of insolvency, in case of financial crisis, the personal property of a partner can also be taken into charge. Okay, but when we talk about company, all the members have limited liability up to the extent of the share capital they have bought. Okay, a member of a company will only be responsible to the amount of share capital, not above that. Okay, third difference is a firm cannot acquire assets on its own name, whereas a company can acquire assets on its own name. All the important documents of a partnership firm are signed by the partners itself, but in case of company has its own common seal, company has its own digital signature. If we talk about transferability of shares in company, all the members have an liberty to transfer their share to anybody they wish to, anybody they want. But in a partnership, a partner cannot transfer its share to any other person. It will be done only if they take unanimously permission from each and every partner, and if they unanimously say yes, that yes, you can forego now, you can go to the go from this firm and you can transfer your share to other person, then only this could be done, but no liberty is there for transferability of shares. So these are certain differences that we had left when we were studying limited liability partnership. So there is difference between partnership firm and company. Okay, so these are certain salient features of a company. I hope everything is clear till now. Okay, next concept is lifting of corporate veil. Now, this concept we'll be discussing in brief right now, and in detail we'll be studying this in next topic. In details mean what? In every point here there is a case law. So case laws I'll be discussing in the next class, and provisions we'll be discussing today. So lifting of corporate veil. Veil means what? Veil are the curtains. So uh, if we go on grammatical meaning of this word, lifting of corporate veil means that somebody is trying to unveil you, somebody is trying to lift this corporate curtain. Now what does that means? Because we have already studied that company has a separate legal entity, that is company is different and members of the company are different, right? So because of this advantage, many members of the company started misusing this feature of the company and started earning profits. Okay, now what did they do? They started building companies just for tax saving, because the concept of company, there are many benefits. If you are opening a company, you'll have many relaxations in taxation policies also, if you are doing business via mode of company. Okay, so what people started doing, that they started creating dummy companies just for tax saving purpose. So if the government, if the judiciary finds anything fishy in your company, if the judiciary or the government finds anything going wrong in your company, then you cannot hide yourself, you cannot give yourself a shelter of this corporate veil. Okay, now if you are doing anything, if you are misusing the concept of separate legal entity for your own benefits, for your own profit making, then the government has a power to lift this veil, to lift this curtain up, and to find who the real culprit is. So to find out the real culprit, because what happened now, in many cases, there was found that uh, people started misusing this thing that I am the member of the company, so you cannot take any action against me, take anything against the company. But company is an artificial person. What will you do of that company? Members are creating fraud, not company. Okay, so in that case, the court decided that if there is something fishy in any company and it is found that members are doing something wrong, they are taking shelter in name of separate legal entity, then in that case the concept of separate legal entity can be completely removed and each and every member can be taken into account. So in what situations corporate veil can be lifted? Firstly, if any company is formed for protection of revenue, that is if court finds that company is formed for tax evasion purpose. Okay, if any company was built for just saving the taxes, then in that case company the court has a power to unveil this corporate or to unveil this company. Okay, and the company, sorry, and the member can be held responsible for their conduct. Okay, and company can be set aside. So this is one criteria where a corporate veil can be uh, lifted. Second is determination of enemy character of a company. देखो वैसे तो क्या होता है ना, company is an artificial person. Okay, so company cannot be anybody's friends or enemy, because being friends or enemy is emotional attachment. Okay, so company does not have emotions because it is not a natural person. But this situation arises in case of war. In case of war, what happens is there are certain situations, like for example, world war was going between Germany and England. Now for example, if um people of Germany are having a company in England, this company is run by German people. The members of the company are German, the creditors of the company are German, the profit is also going to Germany, but the company is there in England. So during war, what happened was, now these both countries, that is Germany and England, became alien enemies. So it was necessary to lift the corporate veil to find out that they are not involved in any political activities. Okay, so in case of war, in case of these kind of situation also, a corporate veil can be lifted and members can be held questionable. Okay, so if there is any determination of enemy character of the company, then the corporate veil can be lifted. Now if we find out if any Pakistani company is there in India, so those members of that Pakistani company can be held responsible for anything. Okay, so in these circumstances also corporate veil can be lifted and separate legal entity concept can be foregone. Okay, and each and every member can be held responsible. Next is prevention of fraud. If it is find out that company is doing, if members are doing fraud with other people on the name of company, then in that case also corporate veil can be lifted. Many cases happened in all these points that we'll be discussing in the next class. Right now I'm just giving you a brief description that what corporate veil is and how it can be lifted, when it can be lifted. So if the court finds out that members are involved in some fraudulent activities and they are misusing company's name for these kind of fraudulent activities, then in that case also corporate veil can be lifted. Next is protection of public policy. If you find out that any member of the company is not is misusing the power of the separate legal entity and doing some acts which are opposed to public policy, which are not good, which are not in favor of the public, then in that case also court can interfere and lift the veil of corporate and lift the corporate veil. Now for example, you have created a company and under the name of the company you are doing something which is opposed to public. You are doing some, for example, you are selling women outside the country, or you are smuggling drugs, etc. So you are opposing public policy. So their company will not be responsible, you will be responsible, because you are doing that particular thing. You cannot take the excuse there that I am member, you just take action against company, not me, I can be escaped. No, nothing can happen like this. Because in this situation, when you are doing something which is not good for public, then in that case corporate wheel could be lifted and real culprit could be found out, and real culprit could be punished. Next situation where company is a mere sham or cloak. Mere sham or cloak means what? It company is just for a dummy purpose. What the members are doing, they are just company is just for namesake, that yes, this is a company, but everything under that veil is done. People are creating fraud, or people are misusing the powers of the company. So in that case, if you have created just company for just name purpose, then in that case also corporate veil can be lifted and you can be held responsible. Next is where company acts as an agent of its shareholders. If the court finds anything fishy, that this company is just acting as an agent of the shareholders, okay, this company is just giving benefits to the shareholders and doing nothing else, then in that case also corporate veil can be lifted and the members can be held responsible. Next is avoidance of welfare legislation, where a company is trying to avoid any legal legislation. Okay, so their court finds something fishy, that why this company is avoiding legal legislations. There might be something wrong. So the court can intervene and court can lift the corporate wheel, and court can just put the separate legal entity concept ahead and can find the real culprit. So if you are escaping from any kind of legal legislation, then in that case also corporate veil can be lifted. And last is to punish for contempt of court. Contempt of court means what? If you do not obey the decisions of the court, if you are not disciplined in the court, if you are not respecting the judges of the court, then a case of contempt of court can be filed on you. So if the company has created any contempt of court, then in that case corporate veil can be lifted, and the actual member who has disobeyed the judges, who has disobeyed the this court, can be found out and he can be held responsible. So generally the concept says that company is a separate legal entity. Okay, company is a separate legal entity. That is, company is an artificial person, and is, if anything goes wrong, you can take action against the company and members are not responsible for anything. But this concept of lifting of corporate wheel is an exception to the rule separate legal entity. In these points that we have studied, in these points, the separate legal entity can be kept aside, and the members can be held responsible for the acts they are doing. So this is the brief description of what corporate wheel is, lifting of corporate wheel is. Now, in each and every point, we'll be discussing a case law in the next class. There is a case law for each and every point, there, like we have discussed right now, Salomon versus Salomon. Similarly, there are many case laws related to these topics also that we'll be discussing in the next class. So that's all for today. In the next class, we'll be discussing the case laws of these points, and even we'll be discussing types of companies. So be prepared. In next class could be a quite lengthier one. Okay, it might extend to 8 o'clock. So be prepared in the next class. Okay, that is day after tomorrow. If you have any doubt till here, you can ask me, and if you don't have any doubts, then you can leave the class. Okay, that's all for today. Thank you, everyone. Okay, I hope you have no doubts. So thank you everyone. Have a nice night.